Court is calling 2018 CR 1071 State versus Christopher Salinas. Could I have parties announced for the record for the state?
Salinas. Megan Galloway from state.
For the defense?
Robert Featherston representing Mr. Salinas.
And are you Mr. Salinas?
Yes, ma'am.
Mr. Salinas, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Christopher Salinas who's placed on deferred adjudication in 2018 CR 1071 for the offense of possession with intent to deliver a controlled substance, penalty group 2, 4 to 400 grams on July 6, 2018 for a period of 5 years and extended for a total of 2 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 5 in Bexar County, Texas. The defendant, Christopher Salinas, did then and there fail to report to the supervision officer as directed for the months of May, June, August, October, and November of 2024 in violation of condition number 5.
How do you plead to that? True or not true?
True.
State.
We leave and abandon the remainder, Your Honor.
Any objections?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to life in prison and up to $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes.
Court will find violation of condition number 5 true. Is there a proposed agreement?
There is not, Your Honor. Based on the allegation that was pled true to, the state is asking for 5 years TDC.
All right. Defense. I mean, the rank, that's the minimum.
Yes, Your Honor, and we're not in agreement on that.
All right. What are you requesting, counsel?
Your Honor, the court needs to be aware that in April of 2023, Mr. Salinas went into the hospital to have L3 and L5 on his spine repaired. He remained in the hospital for 3.5 months and then was released. Since that time, he's been in constant chronic pain from the spinal repair. His chronic pain, Judge, has led to his continued drug abuse that led to his failures to report. It's led to his failures to provide samples for urinalysis. He recognizes that he has a drug addiction problem because of his chronic pain, and that has not been alleviated. He's been unable to work. He can't stand for long periods of time. These are contributing factors to his failure to report in 2024 to his probation officer. He's not committed any new crimes that have been alleged in the MTR. Probation is recommending substance abuse treatment facility. We would like the court to consider that recommendation of substance abuse treatment facility. Mr. Salinas would like to go to SADF and successfully complete that in hopes of getting control over his chronic pain and then getting the appropriate prescriptions subsequent to be able to handle his pain. And then we're respectfully requesting that the court consider an 18-month extension as recommended by probation in order to be able to accomplish these goals. And I thank the court.
Thank you. All right, Mr. Salinas, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Christopher Salinas.
All right, so your attorney said that you were in the hospital, and I'm taking that as true, counsel.
Thank you, Your Honor.
So my question is, you were in the hospital April 2023, and you were there for 3 months. So that means May 2023, June 23, July 23, and I'm going to even give you August 2023.
I was actually, after that, I went to physical therapy for a month.
Okay. No. I'm giving you,
okay.
I'm giving you 4 months after that.
Yes.
So you're in hospital April 2023, and I'm giving you till September. I'm not even going to consider you're not reporting September 2023 from April 23 to September 2023. So October, did you call probation?
Yes.
No. Here's the thing. Did you pick up the phone and tell them, I'm going through some problems and I cannot report?
No.
All right. Have you done anything on probation?
Yes, I've done some community service. I mean, I did about 12 hours
Okay.
recently. And
All right. So that's 12 hours. You were placed on probation with a previous judge since 2018.
right.
And from 2018 to now, you're telling me you've only done 12 hours of community service restitution?
24 total.
All right. 24 hours since 2018.
Yes.
And you were actually in court with me on January 17, 2023. A previous motion to revoke had been filed, and it was withdrawn for your conditions to be altered and amended. And those conditions from January 17, 2023 was to do 90 sober meetings in 90 days. You were supposed to be residing with your mother. Did you continue to reside with your mom?
Yes, I still live with my mom.
All right. And then you were supposed to do the UA hotline until further notice. And you're supposed to be doing intensive outpatient treatment. There was supposed to be regular reporting by Zoom or in person. So you didn't even have to go in person. You could have done it by Zoom. And there were to be field visits 2 times per month and partial GPS for work. And then you were allowed to run errands or whatever you need to do on Saturday and Sunday from 8 a.m. to 5 p.m. And you haven't done anything. That's the problem. So I don't think I should continue you because you haven't done anything. And in this court, what do I always say? If you have an issue, pick up the phone, call probation. If you feel they're not addressing it, you can always come to court. And I know that I would have told you if you have a drug problem. In this court, my thing is, if you have a drug problem and you think you're going to use, pick up the phone, call probation. I'm not looking to revoke people because they have a drug problem they're about to use. I'm looking to try to get you help so you won't use. But you didn't do any of those things. And you've been extended before. And the fact that you've been extended before, that means that there have been problems before. Otherwise, nobody would have extended you. And so you've been on probation since 2018, and you really have done nothing. So I'm not going to continue you.
Yes.
Yes.
From 2018, I completed all my programs that I was supposed to complete. And the reason why,
You told me the only thing you had done was community service hours.
before that, that's when when we came back the first time.
Did you do your 90 sober meetings in 90 days?
I've done meetings. I have
Now, did you do your 90 sober?
completed. No.
All right. I just don't think you're a good candidate for probation. And let me explain to you, one, I'm finding it true based upon your plea of true. But here's the thing. You have to at least try. There's nothing I can do if people don't try. And I can't continue to give chance after chance when people don't try. I mean, the only other thing left for probation to do is to come to your house, give you a ride to their location, or either come to your house and sit down with you and bring somebody to, have the classes come into your home, and they don't have the finances for that.
Your Honor, may I address the court?
Yes.
Judge, everything that you say is quite logical about what should be done on a community supervision program. Here, for Mr. Salinas, there is this extenuating circumstance with respect to his back problems. A very extensive stay in the hospital. It's quite uncommon to hear of a 3.5-month stay in a hospital for anything nowadays. So there was something significant there. And quite frankly, I'm not a medical doctor, and I don't really know much about L3 and L5 in your spine.
Oh, no, I appreciate what you're saying, that for them to keep you in the hospital for 3 months, it is extensive.
the court's explanations with respect to 2024, because this is in 2023, with 2024 is quite valid. But this is a gentleman that found himself, he's out now of the hospital. He doesn't have a job. He doesn't have insurance. He's got chronic pain. He needs medication for that. So he goes to controlled substances for medication of that. And now the fear factor for going to probation is through the roof, because he knows if he goes to probation, he knows he's going to have to give a sample, and he's unsure as to whether probation is going to consider his chronic back pain as an adequate explanation. And I understand his fears are valid in that respect. If it wasn't for his back surgery, Judge, I would have no leg to stand on with respect to revocation. I'm asking the court for its mercy here with respect to Mr. Salinas, and allow him to complete an inpatient drug treatment program, and then allow him to go ahead and complete his community supervision program. I thank the court for its time.
All right, thank you. And I want you to know, I heard your counsel's argument, and I think it's a very good argument. But the issue is 2023. Here we are in 2025.
Yeah.
Yes.
Thing is, I had a surgery in my lower lumbar, disc 5 and disc 3. I didn't get it repaired. They had to shave it off. So it's very fragile.
No. I understand it's fragile, but here's the thing. You didn't even pick up the phone to call probation.
My probation has the copies of all my medical records.
No, did you pick up the phone and call probation? Because let me explain something to you. The allegations in the motion are that you didn't report for May, June, August, October, and November of 2024. What that means is you didn't go to their office, you didn't call them, you didn't do any of that.
June, July, August, September.
I mean, you pled true to June, August, October, and November 2024, and May of 2024. You pled true to that of not reporting.
I've seen my probation all the way up to September. October is when I stopped. Since from there to there, I have reported.
All right. So
that's a misunderstanding. Okay. So since October and on is when I stopped reporting. Before that, I've talked to probation officers. I've been to the office.
Here's the thing. I don't know why you stopped reporting in October. All you had to do was pick up the phone. Right? And you know, because you've been before me before, you know that if there's an issue with probation, let the court know. You know, if there's an issue where you think you're going to use, or you have a drug problem and you're feeling weak with drug use. That's why I did the 90 sober meetings. And that's why I said, if there's an issue, let probation know, and then we will address it. Your counsel can tell you normally, unless there's something else going on, if somebody has a drug problem and they're actually trying to maintain their sobriety, I normally don't revoke for that. Right? So the court is finding violation of condition number 5 true. The court will find you guilty. The court is going to grant the motion, sentence you to 5 years in prison. That's the minimum. And I'm doing the minimum because, one, the state requested it, and also considering your health issues. Give you credit for any time served. I'll recommend the therapeutic community, and counsel, I'll retain jurisdiction. I'm not sure if he qualifies for that because I don't have his history before me, but if he does, I'll retain jurisdiction.
Thank you, Your Honor. And if the court would entertain a suggestion, because of his back issues, with the court consider a full house arrest at his house?
No, I will not do that, but I appreciate your asking.
Thank you, Your Honor.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Are you sentencing to 5 years TDC?
Yes.
I have never even been in trouble
All right.
Since from 2018, this is the only reason why I'm keep coming back from failure. I've never gotten a new case or anything. Honor, please.
All right.
I'm
So
done.
did you review the trial court certification of defendant's rights to appeal with your attorney?
Yes.
All right. Because this is not a plea bargain agreement, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. I understand what you're saying. There are many people that come before me. Guess what? They've never been in trouble before. This is their first case and it's a felony. But by that same token, do you know how many people who have never had a case, they're not on probation? I mean, I can only help you with your probation if you show up. Otherwise, I can't help you.
Yeah.
Charles Oneless. Thank you. Hello.
Hi.
Court is calling 2024 CR 011467, State versus Charles Loring Oneless. Could I have parties announced for the record? I believe that's for the court reporter. You can just sit it there.
Okay.
All right, could I have the parties announced for the record for the state?
Andrew Harris Salem.
Defense?
Joseph upheld for the defense.
And are you Mr. Oneless?
Yes, Your Honor.
All right, counsel, have you received all discovery? Did you review it with your client?
I believe I have, Your Honor, and I have reviewed it.
All right, so everyone, no talking behind the court reporter when the court is on the record. Court will find that the state is in compliance with discovery. Is there any applications in this case?
No applications, Your Honor.
All right, Mr. Wanless, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
No, Your Honor, proceeding in a lesser included criminal mischief greater than $750, but less than $2,500.
I'm sorry, you're whispering.
Proceeding on the lesser included criminal mischief greater than $750, but less than $2,500.
Any objections?
No objections, Your Honor.
All right, so off the record. So since you all are, yes, so if you all are proceeding on that, the lesser included offense, y'all are going to need to change this to the range of punishment, the misdemeanor range of punishment. So that he can say that he knows it. So if y'all will just put, and you can put it underneath the second paragraph.
I wasn't sure the best way to do that, Judge, but I
Oh,
thought
no,
we may have run into a problem.
other.
I mean, this,
You want it on the second page
well, if you put it on the admonishments,
on here?
yes, just so that he can be aware. And so under that first paragraph, if you'll just put the charge and then put up to 1 year in the Bear County Jail and up to a $4,000 fine. I just want to make sure that you know.
Okay.
And I
the
wasn't
range
sure,
of punishment.
and I wasn't sure the proper way to do it on their paperwork either.
Oh,
Judge.
no
I just
problem. You know, sometimes it's best to use not the state jail felony paperwork,
Mhm.
but to use the other paperwork. And then on that line, just put
And
the
right
range of
stuff.
punishment. All right, so we're going to go back on the record. So the state is proceeding on the lesser included offense of criminal mischief as a Class A misdemeanor. Defense, any objections?
No objection, Your Honor.
All right, so Mr. Wanless, the state is proceeding on the lesser included offense. So they're not proceeding on the state jail felony. So your range of punishment is up to 1 year in the Bear County Jail, and it's up to a $4,000 fine. Do you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do believe he is, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Wanless, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
All right, according to the plea, punishment is to be assessed at 199 days. Any objection to the court writing in the words Bear County Jail?
No, Your Honor.
All right, punishment is to be assessed at 199 days in the Bear County Jail. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
Contained in Exhibit 1 and attachments, Your Honor.
And we've had an opportunity to review those and have reviewed them. We have no objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney?
Yes, Your Honor.
Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments, and the court will review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
With the court's permission, Your Honor, yes.
All right, anything you wish to say on behalf of your client?
Just that he has accepted responsibility for this, Your Honor. He does have 199 actual days in the Bear County Jail. We respectfully request you to follow the plea bargain, give him credit for all time served, and any time the money's thrown concurrent, and show the judgment satisfied.
All right, the court will find you guilty. The court will sentence you to 199 days in the Bear County Jail. The court will give you credit for any time served, and the court will show that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, Your Honor.
Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because, do you understand?
Yes.
All right. So we can go off the record. Mr. Wanless, I read the police report, so I know there are some mental health issues. Have you been on the medications at the jail?
Yes, Your Honor.
All right. So when you're released from the jail, and I'll have the court called over to the jail to make sure that you're not released at midnight, because that's usually what happens. I'm going to see if they can release you during the day. You'll need to make sure that you set up your medications. You understand?
Sure.
So
I'm going to go to the Center for Healthcare Services, Your Honor.
yes. All right. Make sure you do that. If for any reason something happens and you can't get in the Center for Healthcare Services, or you're lost and you don't know where to go, you can always come back here and we'll make sure that we find a place for you. Okay.
Perfect, Your Honor.
All right. Good luck to you.
Thank you, Your Honor.
You're welcome. Who is here on Nicholas Henderson? All right. Court is calling 2022 CR 4823, State of Texas versus Nicholas Henderson. Can I have parties announced for the record for the state?
Megan Galloway for the state.
Defense?
Michael Bellable for Mr. Henderson.
And are you Nicholas Michael Henderson? Did you review the document entitled Motion to Revoke Community Supervision and state's motion to supplement pending motion to revoke probation with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Nicholas Michael Henderson who was placed on community supervision in 2022 CR 4823 for the offense of theft of property 2,500 to 30,000 on July 5th, 2023 for a term of 4 years? Is that you?
Yes, ma'am.
All right, state.
Your Honor, we're proceeding on the supplement motion, and that's going to be violation of condition number 4 in Gibson County, Indiana. The defendant, Nicholas Michael Henderson, did then and there fail to report to the supervision officer as directed for the months of July, August, September, October, and November 2024 in violation of condition number 4.
How do you plead to that? True or not true?
It's true.
State.
We waive and abandon the remainders, Your Honor.
Any objections?
No objections, ma'am.
All right. Did you understand by pleading true to violation of condition number 4, court could find it true, grant the motion, sentence you up to 2 years in the state jail facility?
Yes, ma'am.
And knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor. We are asking that you grant the state's motion, adjudicate the defendant guilty and revoke his community supervision and sentence him, will reform the judgment to reflect a sentence of 1 year in the state jail.
All right. You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Nicholas Michael Henderson.
All right, Mr. Henderson, why were you not reporting?
I hit a bad spot and just kind of gave up. I mean, there's no other way to put it than that. I really just kind of gave up at one point. I reported to the ICOTS officer here in San Antonio. I did report one time to the Elizabeth Greenwell, which was there in Indiana. And we was on a phone contact base at one point, and I just kind of threw my hands up.
So
There's no other way to put it to you than that,
Okay.
really.
Did you complete anything?
I was paying my fines. I had started doing the cognitive thinking program. I didn't complete it, but I was going through it. I was on step 11 at that point, so I was almost there. Other than that, I was just trying to stay busy with a new career, and had a lot of good happen, but that doesn't excuse anything.
All right, probation. Does he owe restitution? All right, and does it show that he started any programs?
The MRT. He started more with regulation there, so
All right, that's it?
yeah.
All right, did you start the theft course?
I had it set up for online, but I didn't start it yet. No, ma'am.
All right, the court is going to grant the motion. Find a violation of condition number 4 true. The court is going to sentence you to 2 years in the state jail facility, give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I understand.
All right, good luck to you, okay?